Hello, Claire.
Hello, Anson.
What can you tell me about USTR fees on China-linked vessels?
Thank you. As from 14th of October 2025, China-linked vessels face additional fees when calling at a US port. It's a hot topic and one that involves many considerations. For example, what's meant by China-linked, what fees, how the fees are applied, and for which vessels. The USTR provisions apply different regimes for different vessels. And many of those points require US law analysis too. In these 3 minutes, I'd like to focus on what parties are doing from a contractual perspective to determine who ultimately pays for the USTR fees, where their fixtures are subject to English law. And that's against the background that, in the first place, it's the vessel operator who will be required to pay the fees in the US. Over the last few months, when the proposals were first presented, ship owners and charterers alike picked up their charter parties and COAs to consider how the fees might be passed on to charterers or how charterers would push back. At Hill Dickinson, we considered ways in which the fees might be defined. For example, are they port fees or other usual expenses? For example, under Clause 2 of the NYPE form, and in which case would normally fall to charterers. Or are they taxes or dues? And if they are taxes or dues, is that on the vessel or perhaps even on the cargo? Other factors we've considered are implied indemnity provisions or material adverse change type clauses, or other clauses that might provide that new unusual taxes imposed after charter parties agreed for a certain way. Or where charter parties give freedom, perhaps to refuse to go to the US or even terminate a contract. More recently, BIMCO published a model clause that parties might incorporate into time charters. Intertanko have also produced their own clauses. Looking at the BIMCO clause for time charters, it defines the USTR fees broadly, any taxes, fees, dues, levies, port entrance fees, or other charges arising from the USTR notice, as that's defined. And broadly, the BIMCO clause provides that time charters shall take the hit for the fees, although there are some exceptions for breach of charter, etc. Also, in balancing interests, the BIMCO clause sets out requirements for the ship owner to declare if they have any China links, but that is on the basis that charterers request this information. And of course, as in often happens, charterers and ship owners may well agree their own amendments to these sort of clauses. The position under voyage charterers is trickier in that generally ship owners cover the costs of the voyage. But again, it very much depends on the terms of the particular charter party contract. So in summary, it's important for charterers and ship owners to consider their charter party terms to avoid what could be an expensive surprise.